EAGLE Act is a bipartisan bill, and it raises the per-country caps on family-sponsored immigration visas and phases out over a period of 9 years per-country caps on employment-based immigration.
Committee on two immigration reform bills, HR 3648 or EAGLE Act of 2022. It begins to address the extensive green card backlog. The legislation eliminates per-country caps on employment-based visas and raises, I believe, other urgent priority immigration issues also need to be addressed as Congress, ranging from permanent residency for dreamers to providing secure and stable immigration for agricultural workers. Can you please share with us why the recapture of green card visas is not included in the EAGLE Act, which is, I know, something that you've supported and viewed as needed if we're going to seriously address the green card backlog?
Well, it's something, the recapture of visas is something I support, as you've mentioned, for a couple of things. One, I mean, the Congress intended that a certain number of visas be allocated each year. The only reason why they are not distributed is bureaucratic failures. And so the argument for recapture is a sound one, but it's not one that we got support for in the United States Senate. And so that's why it's not included. We want to get something passed. We want to get something enacted into law. There's a lot of things I'd like to do, but I'm trying to do something that is achievable in these two bills, and that's the main reason.
So the effect of HR 3648 will be that every Chinese and Indian national who is currently waiting for the green card, and I think I said this in my opening statement, will now be able to get a card, but it might be issued by a different country. And I think, once again, that's a workaround. And it's not something that I think many members would support. And that, to me, seems like a bipartisan issue that, that there would be opposition based on that specific item. Okay. In HR 3648 are simply last-minute attempts by my colleagues on the other side of the aisle to appease immigration advocacy groups in a few short weeks left on the Democrat House majority. These bills will not improve our immigration system. They will not secure our southern border, and they do nothing to address the Biden border crisis. I oppose them, and I would yield back.
Ms. Lofgren.
Thank you, Mr. McGovern. Today, we're going to take some important steps forward on these two bills, the EAGLE Act and the Veteran Service Recognition Act. Let me go into them one by one. First, the EAGLE Act is a bipartisan bill, and it raises the per-country caps on family-sponsored immigration visas and phases out over a period of 9 years per-country caps on employment-based immigration visas. The bill also includes significant improvements to the H1B visa program that adds protections for U.S. workers. I think it's worth thinking back to how this whole system works. On the employment side, in order to be eligible for an employment-based visa, the employer has to advertise and prove that there's no one here that can do the job that you've been offered, in which case a labor certification is provided and you can seek a visa. That's merit-based. Here's what happens after that. Once that merit-based process is undertaken, then the visas are allocated based on where you're born, really contrary to how we operate in America. We should be based on merit, not where we're born.
In June 2021, a bipartisan legislation was introduced in the House of Representatives to remove the per-country cap on immigration visas, or green cards. In April 2022, the draft of the EAGLE, Equal Access to Green Cards for Legal Employment, Act, was passed by the U.S. House Judiciary Committee. And in DEC 2022, a bipartisan Senate duo has launched a last-minute push to enact immigration reform before the end of the year. In this video, we will get to know, what is the EAGLE Act? Why this bill is being introduced? And if it becomes a law, what to expect from it.
Visit us at Swat&Vee channel with your questions to see how best we can help you out with your process. Please don't forget to subscribe if you're new to the channel.
Now, let's get into the video and discuss it further. A green card allows a non-U.S. citizen to gain permanent residence in the United States, but getting green card is not an easy process nowadays. It takes about 3 to 4 years for a green card to become available for applicants from most of the countries around the world. But it can take decades for the citizens of countries such as Mexico, China, India, and the Philippines. United States government follows the Immigration and Nationality Act to allocate the green cards every year, which allows total 140,000 employment-based green cards available per year, with a limit of 7% or 9,800 green cards per country. The 7% per country cap is fixed, regardless the size of the country. A country like Iceland with a 356,000 population gets the same numbers compared to the countries like Mexico, China, India, and the Philippines, which has millions of populations. In June 2021, the Equal Access to Green Cards for Legal Employment (EAGLE) Act of 2021 was introduced by Democrat Representative Zoe Lofgren and Republican John Curtis, expected to benefit the U.S. economy by allowing American employers to focus on hiring immigrants based on their merit, not their birthplace. In April 2022, the U.S. House Judiciary Committee has passed the draft bill of the EAGLE Act to raise the 7% per country limit on family-sponsored and employment-based green visas to 15%. Over the years, there have been many bills that were introduced in the U.S. Congress to remove the per-country caps for employment-based green cards, but none of them got passed by the House and Senate. Recently, in year 2019 to 2020, Congress worked on two bills, H.R. 1044 and S. 386, to address the same issue. And both the bills were passed by Senate in December 2020. But due to some disagreements on Chinese military and Communist Party associated clauses, the bills were never reached in House of Representatives for final session. Then on June 2, 2021, the EAGLE Act 2021 introduced in House as H.R. 3648 is based on final versions of the H.R. 1044 and S. 386 that focuses to remove the per-country limit. Now, let's look at the various important clauses of the EAGLE Act 2021. Clause number 1. Remove per-country limits for employment-based green card petitions. The main objective of the bill is to eliminate the per-country base limits for employment-based green cards allocation based on country of birth. The current limits are set to 7% or 9,800 per country for the same. If EAGLE Act 2021 becomes the law, it will eliminate the per-country limit. Clause number 2. Increase the per-country limit for family-sponsored petitions. The EAGLE Act 2021 also increases the limit of family-sponsored green card petitions from 7% to 15% per fiscal year. Now, let's move to the clause number 3, when this bill be in effect. Usually, a new bill become effective from the first day of the second fiscal year after the bill is passed and signed into law. That means, if the bill is passed before October 1, 2022, it would be effective from October 1, 2023. Now, let's move on to the Clause number 4. Rules of transition period. There is a 9-year transition period after the EAGLE Act is in effect, to better transition and not have major two countries, like India, China, take up everything. The transitions rules are: for first fiscal year after effective date, October 2023, September 2024, 30% reserved for rest of the world, ROW, and only 70% to be allocated to major countries like India, China. For second fiscal year after effective date, October 2024, September 2025, 25% reserved for ROW, 75% available for major countries like India, China. For third fiscal year after effective date, October 2025, September 2026, 20% reserved for ROW, 80% available for major countries like India, China. Fourth fiscal year after effective date, October 2026, September 2027, 15% reserved for ROW, 85% available for major countries like India, China. Fifth and sixth fiscal years after effective date, October 2027, September 2029, 10% reserved for ROW, 90% available for major countries like India, China. Seventh, eighth and ninth fiscal years after effective date, October 2029, September 2032, 5% reserved for ROW, 95% available for major countries like India, China. It is important to note that during the 9-year transition period, no country from the rest of the world can take up 25% of the total reserved green cards numbers/visas. No country can take more than 85% of the unreserved visas numbers. And if any of the visas are left over or unused due to the clauses as listed above, like per country levels and reservations, then such visas should be given to the remaining ones in line without applying such restrictions. Now, let's move on to the clause number 5, reserved visa for rest of the world with approved I-140. For first 9 years from the effective date of the bill, 5.75% of the employment-based green cards would be given to the rest of the world, not major countries like India, China, who have an approved immigrant petition, I-140, but waiting in line due to backlog, in the following order. A. Family members joining primary green card applicant as dependents. B. Green card applicants, who have not lived or worked in the U.S. at any point in the previous 4 years since they filed their green card petition from outside of the U.S. C. Any other immigrants from the rest of the world countries, who are waiting in line with approved I-140 for their green card slot. Now, let's move on to the clause number 6, H1B program, LCA process changes in EAGLE Act 2021. Point A. Post H1B jobs on Department of Labor. Within 180 days from the effective date of the bill, the Department of Labor, DOL, should set up a searchable internet website to post the H1B positions that are available to be viewed by public for free. The job must be posted for at least 30 days on the website and must have all the required information.
Point B. H1B employer application requirements for new applications.
For new applications, the employer or anyone hiring on behalf of the employer should not advertise the position saying that it is available only to H1B holders and there will be a priority for H1B applicants. If the employer already has H1B workers, they need to submit the IRS W-2 forms related to H1B workers to the DOL secretary. The LCA should also have the prevailing wage determining methodology information. Point C. If the employer has 50 or more employees in the U.S., then the sum of H1B and L1 visa holders cannot be more than 50% of total employees. Point D. New H1B LCA fee. Currently, there is no fee for filing LCAs. As per the current passed bill, for administrative expenses, DOL has to come up with a fee for LCA filing. Point E. Elimination of B1 visa in lieu, instead, of H1B. As per the text in bill passed in Senate, U.S. State Department should not issue B1 visa for short-term work contracts, instead of H1B visa. And point F, employer should follow the H1B labor condition application, LCA, wages, compliance. Now, let's move on to the clause number 7. Adjustment of status, dependents, work authorization provisions. Point A, apply for adjustment of status, I-485 application. You can apply for adjustment of status using I-485, both applicant and eligible dependents if you have your immigrant petition, I-140 application, approved or pending for more than 2 years. So, you do not have to wait for the priority date to be current to apply for the adjustment of status, I-485. Point B, dependent child aging out, adjustment of status. If you file for adjustment of status as described above, then your dependent child will continue to qualify for the application of a green card, irrespective of the age of the child. This is the one that many refer to aging out of children waiting for their green card. Point C, deceased principal applicant. If you file for adjustment of status, then you will continue to be eligible for a green card as a dependent, even if the principal applicant has died. This provision is to address the situation where the primary applicant is deceased and spouse, children must leave the country. Point D, work authorization, travel permission. The applicant who files the adjustment of status, I-485, as per above, will be eligible for work authorization and travel permission, advance parole, as well. Point E, the approval of adjustment of status, I-485, application file will not be approved until the priority date becomes current. Point F, duties, hours and compensation, the terms and conditions, working hours, compensation, duties, etc. For the applicants who have filed adjustment of status application, I-485, must be similar to U.S. workers working in same area. Even if the employer does not have anyone employed on similar terms, the employer is obligated and needs to attest that they are providing similar terms and conditions, duties, etc.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!